Good afternoon. Oh, wow. Okay, yes, it's working. Hi, my name is George Cheung. I'm the program director of the Democracy Program at the Joyce Foundation. We're based in Chicago, and we work to improve the quality of life in the Great Lakes region. Just before we begin, I'll just tell my quick story. It all goes back to geometry class in high school. My geometry teacher, the one thing that I remember from that class is that he said, if you don't know the rules, you can't play the game. He was talking about it in a slightly different context than redistricting, but the same thing applies. If we don't know the rules of the game in terms of how our elections are run, we can't reform and improve them. I remember when I was in my 20s, I was redistricted from one congressional district to another, and I thought it was awesome because I felt that my vote actually counted. I was in a competitive district, and I didn't really think about it much until I became a fair housing investigator for state government in Rhode Island. At that point, I had read this great book that had come out at that time called American Apartheid, and it really talked about the intersections between segregation, residential segregation, and political representation. And at that point, I really thought, wow, we have a system that, at its worst, seeks to pack a lot of people in the same districts, and then the result is that only people who represent those districts care about what those people really want and need. So what does that mean for coming to good public policy for everyone? So today, I'm really excited to be here to moderate this panel with some very esteemed colleagues. I think for most of us, we think about, probably not in this room, but most of us think about redistricting once every 10 years. But in fact, some of the most important work around political representation and districting happens at the local level all the time. And today, so we're going to hear three different stories at the state and local level about redistricting, districting, and voting rights. First, we're going to start with Ernest Herrera, who is a staff attorney for MALDEF. He's a native of San Antonio and litigates on both educational equality and voting rights. One thing that you don't know about him is that he's a published author of a paper on indigenous people who have been labeled as terrorists by the government. He will be talking about aspects of local electoral changes in the post-Shelby era. Then we'll go to Allison Riggs, senior attorney with the Southern Coalition for Social Justice. She focuses on voting rights and has a long litigation history in redistricting in the South. What you don't know about her is that she spends all of her very few non-work hours on rescuing dogs. She'll be talking about moving reforms forward without the ballot initiative process and using the tools that they have available. And then finally, we'll move to Kathay Feng, Executive Director of Common Cause California. She starred in the blockbuster documentary Gerrymandering. Yes, she did. And she is a cutthroat spades player, so if you're going to play with her, don't bet money. She'll be talking about lessons learned from the California experience. With that said, I'm just going to turn it over to Ernest.
Thank you, George. And one thing, it was in Bolivia where I helped write a book, and I wasn't published under my birth name. They didn't think Ernest Herrera was authentic enough, so I had to add an O to Ernest, and then my mother's maiden name on the end, so I sounded more Latin American. That was the main author's idea. So I want to start out with, as any good political discussion begins in 2016, with a little Klansman. So in this case, we start in Pasadena, and I want to give you the context for Shelby's effects throughout the country, especially in states that were covered by Shelby prior to the 2013, covered by Section 5 prior to the Shelby decision. And in Pasadena, we'll start, which is in Texas. There's a different, not the one with all the actors in it, the one that's full of oil refineries and was the setting for Urban Cowboy, is near Houston, Texas, only about 20 minutes down the highway. And it's not a small town. It's about 150,000 people now. But in Texas, we have the historical context of a long struggle for political participation, not just for African Americans and other minority groups, but for Latinos, which is what MALDEF has focused its work on. Earlier in the 70s, we worked on the White v. Register case, 60s, I believe, and that was an important case establishing rights, voting rights around gerrymandering, redistricting. Later on, throughout this history and throughout the 20th century, there were items such as poll taxes, of course, and Mexican Americans were not allowed to participate in some cases in primaries, and these were called the white man primaries. So political participation was kind of blocked at different routes, not just at the voting booth, but in terms of getting Latino candidates or Mexican American candidates to the ballot box. There is a legacy of discrimination, not just in those areas, but as is outlined by the Senate factors under Section 2 litigation, discrimination in housing, education, civic participation, and public accommodations. And so we'll go to Pasadena, current day. In 2013, there was an 8 single-member district system for the city council there, meaning they're all elected from geographically placed districts. 4 members were Latino or Latino-friendly. There were a couple of Anglos who were Latino-friendly. In Texas, by the way, non-Latino white people we call Anglos. So that's our shorthand. I know it's not the most accurate, but a 5th seat was newly Latino majority, threatening to shift power on the council. And there we had a little picture of our council. And we also have a shifting demographic picture. In the last 20 years, Pasadena went from being a Latino minority city to a Latino majority city. Much of that having to do with immigration, but a lot of it having to do with migration from Mexican Americans and other Latinos within the United States and Texas. Again, Pasadena is a suburb of Houston, and Houston is a massive city. This figure here that says HCVAP, that has to do with Hispanic citizen voting age population. That's a census figure, and that is taken through the American Community Survey put out by the U.S. Census Bureau. And the numbers now reflect closer to 47% HCVAP for the city of Pasadena. So Latinos, while being the majority of the city, are the minority of the voting population of the city. Important to keep in mind in this case. So here we have enter Johnny Isbell, here stuffing his face with some strawberry shortcake. The mayor proposed 2 days after the Shelby decision a change from the 8 single-member district system to a mixed system of 6 single-member districts and 2 at-large seats. The mayor stated that he specifically stated that he could not have made the change under Section 5. In an interview with SCOTUS blog, he said, "The Justice Department can no longer tell us what to do." So indeed, with the dead body of 4B still warm, Isbell called for the formation of a committee to consider changes to the city council election system 2 days later. That was in June of 2013. By November of 2013, we have the change. So, going back to Section 5 and zooming back out to Shelby, I think people here could probably give you a more detailed and really detailed description of the Shelby ruling, but I'll give you the outline. Section 5 of the voting rights, the Shelby decision was looking at Section 5, which covered a number of jurisdictions that were considered bad actors under a formula that was in place under the Voting Rights Act. That formula was done, that was Section 4B. That formula pulled those jurisdictions under a system of federal oversight. The jurisdictions had to get permission to make whatever change they desired to the election system. In Texas, for example, the changes we've had statewide are redistricting, the voter ID laws, which we may talk about later in the questions, but also things, even something like, what are the requirements for you being deputized to register people to vote? In Texas, I can't go as a resident of Bexar County, San Antonio, to Houston and register people to vote unless I also get deputized there. And the classes are very hard to get to. So you can see why, if we go to Pasadena, or the next slide. Thank you. And Pasadena, a change like the change that happened in Pasadena would have been blocked. The city council election map was redrawn because of an election in 2013, November of 2013, to change it to that 6-2 system. The city council is still balanced with 4 Latino-friendly council members and 4 not Latino-friendly council members. However, a Latino candidate who would have won in the old system lost by 50 votes because his district got bigger, it got whiter, it got less Latino. Now, I want to, at this point, bring in something from Shelby. There was a quote from Shelby that was repeated by the majority opinion, and they were quoting another case, Northwest Austin Mudd, saying, "Blatantly discriminatory evasions of federal decrees are rare, and minority candidates hold office at unprecedented levels." Yet, if we go to the example of Pasadena, we have a case where a Latino candidate, a minority candidate, was prevented from winning precisely because there was no more pre-clearance to prevent that change from going into effect. So, while I'm maybe not be the best scholar to give you or legal person to give you the explanation of Shelby, I'm giving you a very concrete example of what's happened in Pasadena. Now, my clients, MALDEF's clients, have sued the city of Pasadena, and we're currently in litigation over that change to the election system. We wanted to go back simply to what it was before, and that we've had to bring under Section 2 of the Voting Rights Act, which, hopefully stays intact as well. The loss of, we can go, sorry, to the last slide, thank you. Texas voter ID has moved forward under without Section 5 being in effect. As many of you have heard and read, they're the strictest voter ID laws in the United States right now. And the Texas redistricting plan was unleashed at the time. Now, without going through the procedural history, that case is still tied up right now. We're waiting for a district court decision. I got to work with Allison on that case in San Antonio. But point being, there was a very favorable decision under Section 5 litigation in Washington, D.C. over the Texas redistricting plan that found it intentionally discriminatory. But that, because of Section 5 being gone, that opinion was vacated. That means it's poof, it's gone. As one judge in the 3-judge panel in San Antonio said, those proceedings were illegal. We're not going to talk about anything having to do with those proceedings here. So we couldn't even quote testimony or items brought up there. So I know I've gone over my time, but one takeaway I want to offer to organizers, activists, and people in the room with regard to changes happening especially in places that used to be covered by Section 5 is keep track of local elections, especially when there are minority candidates involved. Turnout matters, but also documentation of those elections and how they are conducted, how the campaigns are conducted, all of that matters to this new era of Section 2 litigation where minorities are having to fight in court, case by case, changes to the election system. So I'll leave you with that.
Thanks, Ernest, and thanks for messing with Texas. Next, we'll go to Allison Riggs to talk about North Carolina. Allison.
Great. Well, thank you so much for allowing me this opportunity to speak today. I'm actually going to speak a little bit more beyond just North Carolina, although North Carolina is a great, there's lots of stuff going on right now. You might have heard about us in the news, but my organization has the privilege of litigating and representing clients all across the South. And so I thought I would take this opportunity to discuss two different challenges we found in this last redistricting cycle. And like George said, redistricting may be a once-a-decade event for some, but for us, it's decade round. So previously, we relied on Section 5 to protect minority voting gains and Section 2 to create new voting opportunities for voters of color. Those sort of traditional litigation and advocacy routes have been a little bit upended this cycle, and we've found two particular areas problematic. The first one, if you don't mind, is racial gerrymandering. So we've been involved in racial gerrymandering cases in a number of states in the South, and for those of you in the audience who may not be voting rights attorneys, I thought I would just give you a glimpse of what racial gerrymandering is. So the racial gerrymandering jurisprudence as we know it really developed in the 1990s out of my home state, North Carolina. And it's this idea, it's a 14th Amendment claim, but it's this idea that you would draw a district on the basis of race. In the 1990s, we saw so-called racial gerrymandering used in an ameliorative sort of fashion to create opportunities, particularly in Congress, where voters of color, especially African-American voters, hadn't been able to elect representatives since Reconstruction. In the 1990s, we saw the creation of majority black districts all across the South that started to diversify who we were sending to Congress. Conservatives in the 1990s challenged that redistricting, challenged the drawing of districts on the basis of race, and so we got this jurisprudence that you might have a 14th Amendment violation if race is predominant in factors considered in drawing district lines, and if the use of race wasn't narrowly tailored to advancing a compelling governmental interest. The courts always assumed without deciding that complying with the Voting Rights Act is a compelling governmental interest. That's what came out of the 1990s, and we've seen a shift in this recent cycle where conservatives in control of state legislatures, particularly across the South, were then trying to limit the voting strength of voters of color by packing black voters, packing Latino voters into as few number of districts as possible, claiming that the Voting Rights Act compelled them to do so. So on the ground, we've seen this real-life harm that racial gerrymandering limits the ability of voters of color to influence district elections in a wider number of districts, that it makes assumptions about racial groups' voting behaviors that may not be supported by the data. That is, it assumes black voters will vote one way and white voters will vote another way, and that there's no cross-racial coalition building. And it leads to non-compact districts, and that's problematic on a number of levels. And if we go to the next slide, I think you'll understand why. This is a district that's currently being litigated in North Carolina. It's a state Senate district. It's been represented by an African-American representative for a decade now, over a decade. This is what the district looked like before the 2011 redistricting. It was 42.62% black voting age population. This is what the district looks like now. And I think intuitively we can see why that district is not beneficial for voters or for candidates. It's confusing. It splits a large number of precincts. But also what's important to think about is the increase in the black voting age population really concentrated black voters in that district and limited their ability to affect elections outside of that. So, one of the reasons we are alleging that this is a racial gerrymander will make sense if you go to the next slide. This is a little bit hard to follow. This may be a little bit hard to follow, so just bear with me. These are census blocks shaded by racial density, as particularly in this case it's black voting age population. This district, the lines track where the concentration of black voters are. And this arm that is, we call it the flexed bicep, it's not what my bicep looks like, but goes out into eastern Wake County and pulls into, this is urban Raleigh, it's our capital, it's very it's very urban, very developed. This is a very rural part of Wake County out to the east there. These are not communities of interest. This doesn't make sense as a district. So, you know, this is part of the case that we're making, that race predominated. It's also, you know, we're making the case that the Voting Rights Act doesn't compel this, that voters of color have had a long and demonstrated history of electing their candidates of choice in districts in parts of North Carolina, and this sort of remedial action, this is what the legislature has alleged, that this is remedial action, in fact, harms voters of color. On the next slide, just so you understand, racial gerrymandering, there are variations on the theme. Racial gerrymandering in North Carolina doesn't exactly look like it does in Alabama and Virginia. So in Alabama, the theory was whatever district elects a candidate of color, we're going to say that that district is stuck forever. If it was 65% black voting age population, that's the number it has to stick at, that has to stay at. And so when we redraw lines, what we care most about is keeping the district at the same voting age population. Again, this is a disconnect with what's happening on the ground. You may not need a 65% district to elect a candidate of choice. That may have the effect of creating more non-compact districts and reducing the influence of voters of color in surrounding districts. Virginia had a different variation on the theme. They kept the same number of majority black districts, but decided 55% was the magic number. It wasn't informed by any studies. It's just the magic number they came up with. In North Carolina, we are in our legislature's infinite wisdom decided we needed to increase the number of majority black districts. So we have 40 Senate seats, none of which were majority black before the 2011 redistricting, but elected 8 African-American senators and a number of other senators who the data showed were the candidates of choice of voters of color. The legislature decided they needed to increase all of these districts to majority black status, which, you know, we have a growing Latino population in North Carolina, so if a district is 50% black, it may be 60% minority. It's concentrating minority voters in these districts. And likewise, in the state house, we went from 8 to 24. And the legislature decided the magic number was 50%. All of these districts had to be drawn at 50% black, regardless of their past electoral history, regardless of how the districts came out looking. And next slide. The good news is that the Supreme Court has thus far been amenable to our arguments that, you know, conservatives they fought this fight in the 1990s and we lost, and the Supreme Court established case law that said you can't use race in a predominant fashion unless you have a really, really good reason to. So this, just this past year in 2015 in Alabama Legislative Black Caucus v. Alabama, the Supreme Court, consistent with its 1990s jurisprudence, criticized Alabama for prioritizing mechanical racial targets above other districting criteria when the Voting Rights Act didn't compel it. And since then, we've seen cases in Virginia and North Carolina striking down districts as racial gerrymanders, and the potential for even more cases to result that way is great. So this is one of the big themes that we've seen in this round of redistricting. Another topic I want to touch briefly on, if you'll turn to the next slide, is we also find ourselves with clients all across the South where in situations where traditional Section 2 litigation isn't an option. So by traditional Section 2 litigation, I mean representing voters of color seeking to create single-member districts where at-large elections hadn't created opportunities to elect candidates of choice. But that the framework that has been developed for winning traditional Section 2 redistricting litigation has been limited. And it doesn't work everywhere. So we've got changing demographics throughout the South. Particularly, I represent some clients in Florida where we have large African-American and Latino populations living in somewhat integrated housing patterns with each other so that you can't draw a majority black district or you can't draw a majority Latino district. But that doesn't mean we don't believe that they should be shut out from representation. We also have court rulings, not surprising, from some of the more conservative districts that limit the usefulness of Section 2. I'm just going to skip ahead to the next slide. So one of the clients that I'm talking about, we work with some folks in Lee County, Florida, which is where Fort Myers is, so south of Tampa on the Gulf Coast. Lee County, Florida itself isn't a majority minority. It's about 25% minority voting age population, 20% if you look at citizen voting age population. But the school board, or the school district, now over 55% of Lee County students are students of color. And this has changed dramatically even from a few years ago. So in the 2009 to 2010 school year, it was still majority white. The school board is currently made up of 5 white members. No candidate of color has ever been elected to the school board or any countywide board in Lee County. And our clients came to us because they were finding that with such a diverse student population, the school board didn't understand the experiences and the needs of students in their community. Unfortunately, the way the demographics are, you cannot draw a majority black or a majority Latino district in Lee County. You can't even draw a majority minority district. You can draw a coalition district that's about 45, 48% citizen voting age population. But one of the things we ended up talking about with our clients was alternate voting systems or alternative voting systems, because this was a situation where the traditional Section 2 framework wasn't going to offer any opportunities for relief. I could spend an hour and a half talking about alternate voting systems, and it would be well beyond my time frame. But I want to raise some issues. I think it's a very, very useful conversation. We get resistance, hard resistance, anytime we bring up alternate voting systems from both our clients and from our legislative bodies we're working with or advocating from. There is resistance to change, and alternate voting systems can be difficult to conceptualize and understand. So we've played around with different graphics trying to explain cumulative voting and limited voting. Cumulative voting allows you to concentrate all your votes behind one candidate. Limited voting means you have fewer votes than the number of seats that are open. And so in essence, you're concentrating your votes, again, behind a candidate. These kinds of systems can and have created opportunities for voters of color to elect their candidates of choice. We've seen it as a consent decree option in voting rights cases. But in Lee County, it was one of those things we sort of used as a threat with the local body. No one actually wanted to move to alternate voting systems, but we believed there was the potential for lawsuit to seek that remedy. And suddenly, the threat of that made negotiating about drawing a coalition district that would be advantageous to our clients. It made it more a more palatable discussion. But these are just ways in which we're trying to think outside the box, open up discussions about creating new opportunities that are outside of the traditional Section 2 litigation and situations we've seen across the South. So thank you.
Thanks, Allison. Really appreciate the conversation about alternative voting systems. Please talk to Allison about it, and check out the Fair Vote website as well for more information. I'm just going to take a quick moderator's prerogative just to talk just for a second about census. We all rely on census data in order to have the best representation for our communities. And what's happening right now is that the census is going through a process of making a ton of policy decisions, including making sure that they have enough money to actually roll out a very different census. There will be no form that goes to every household. It will be largely done online. So there's a ton of really important advocacy work that needs to happen over the next couple of years. If anyone wants to talk about it, come talk to me or Adrian over here. We love talking about census. It's hugely important over these next couple of years. So, and now back to our show. Let's go to Kathay and California.
Thanks. George talked a little bit about my secret, which is that I really like to play cards, but ever since I had a child, I no longer play any kind of fun games except for when I get together with George. Let me just give you another secret, which is I am desperately fearful of government surveillance, and so I have turned off my cell phone, and I'm going to ask somebody to keep track of time for me so that The government doesn't know where I am. After hearing that, it just freaked me out. There's plenty of reasons for the government to be tracking me. Let's talk a little bit about how redistricting works generally and take a few steps back, but then I want to skip forward to what's possible. Throughout the U.S.'s history, and certainly the most commonplace way of us drawing districts is generally having those people who are sitting legislators, city council persons, whoever is currently kind of the body of decision-making, be the people who are also drawing lines. And what that oftentimes means is incumbents are drawing their own lines that they will eventually run in. And so you can see where the natural inclination would be for incumbents to draw lines that would entrench their power, and to the extent that it allows them to have job protection for the next 10 years or 20 years or several decades, they're going to be creating that system of tenure that ensures that no challengers are in their district, that donors are drawn in, that communities that might have an inclination to support somebody else besides them would be drawn out. In California, I was part of an effort within the Asian American community to organize communities in the early 2000s to participate first in Census, to fill out our forms, and then to make the connection that the reason why we wanted to fill out our census forms was to be sure that we were counted in the next round of redistricting, and to really introduce our communities to providing testimony about where we were and why the lines needed to be drawn in a way that didn't slice us into multiple pieces. And what I will say is that as a young, naive attorney at the time, I really believed that if we could get a lot of people to the hearings of the Assembly and the Senate to talk about where our communities were and to put a face onto what those communities were about and what we cared about, that those legislators would hear us and would draw lines that respected the community interests and ultimately seek to represent these emerging communities. What I found was so far from that truth that after about 4 months of public hearings, where fewer than this number of people in this room attended those hearings, the legislature went behind closed doors and in 2 weeks drew the lines that they really wanted to. What I also found out was even though the year was 2001, racism reared its ugly head again and again. Time and time again, we heard about stories where legislators said in rooms full of their supporters, we need to excise this community or that community because that community represents a potential challenge to my power, right? This map on the screen is one from San Fernando Valley in the Los Angeles area. It's a suburb of Los Angeles. And again, sorry to force you all to look at these. You know these well. So the dark green, the darker the green, is where, at least here, it's mapped out where Latinos lived. Okay. And in 1991, when a court drew the lines, they created a district where, as you can see, there's a fairly significant Latino population in this district. Well, in 2000, a particular congressman, Howard Berman, and his brother, Michael Berman, had the power to draw the lines for all congressional lines. They took in, or one could say they forced fellow congressional members to pay up in order to draw safe districts for them. But of course, Michael Berman was going to reserve the best for his own brother. And so what did he draw? He made sure that the Latino community, which you can see is around here, was carefully excised. And some 100,000 Latinos were drawn out, and the non-Latino, I guess in Texas we'd call that Anglos, Anglos, probably more like a Jewish American community, was drawn in. In order to protect him from a potential challenge from the emerging Latino population. For myself, my rude awakening was a phone call that I received from a certain senator from the city of San Francisco who called me up and said, Kathy, you are not going to put another fucking Asian in my district. And as a young attorney who thought that we were in the year 2001, I didn't realize that race and politics mixed so inextricably. Next slide. The other reason to reform redistricting is that we have seen this erosion of the Voting Rights Act, and certainly, even though one of those elephants is no longer there, we stand on the precipice right now of where the Supreme Court might go in preserving protections of the Voting Rights Act. We do not know where that ninth justice who's next appointed is going to go, and in so many different ways, we have to be very careful about the direction that we shape this jurisprudence. And to the extent that we cannot be sure where the Supreme Court will go, we need to think about other alternatives in order to protect voters by fighting for better laws, by fighting for better protections that are embedded in our constitutions, in our state constitutions. Next screen. Another reason that I think it's absolutely important for us to think about fundamentally changing the way that we do redistricting is that our population is changing. And so much of redistricting, as I said before, is about looking backwards, right? Entrenching the population of people who got you there, as opposed to looking forward to thinking about where is the demographics going, how do we draw districts that might be reflective of new populations that are emerging. Next. Oh, sorry, yeah. And then lastly, one of the most important reasons that I wanted to fundamentally change it was to just make sure that regular people had a voice in choosing our representatives, but ultimately when they were elected, in being able to seek assistance and services from those electeds. This area in green is the area of Watts, the community of Watts, which is largely Latino and African American. And after the 1991 census, they were drawn into 3 different districts at multiple levels: state, Congress, state assembly, state senate, and Congress. It's a small little community, heavily low income, but to be split into 3 different pieces meant that when they needed help, every time they went to their congressional members, they would be ping-ponged from one office to another. And they would not get the representation that they needed, whether that was seeking federal assistance for FEMA help when they were rained out, or in seeking state assistance for various programs that they were looking for. We had congressional staff tell us that they would do the analysis on the community of Watts and figure out exactly what percentage of voters they were in their own district. And when it turned out that it was only 300 or 400 people, it was so easy for them to dismiss and put low on the priority. So residents were ignored. So we pushed for big changes in California, and I won't bore you with the entire story, but the biggest thing that we pushed for was to change who had the power of the pen to draw those lines, or in this case, the hand on the mouse. We pushed for a citizens commission to be created that took the power from the legislature and gave it to a group of 14 citizens. Next slide. What we found was the naysayers said, nobody is going to care about this. You're going to have this whole big process, and redistricting will continue to be an esoteric topic that nobody gathers around, nobody convenes for. You won't have anybody who will apply for this commission, and it will still fall back into the same hands of the insider politicians. What we found was, with a great deal of investment and intentional organizing, right? Intentional, and I say that because it didn't happen without specifically acknowledging that if you just left it to be, those who are most involved in politics would still participate, which in the first round of applications for our commission, that meant that primarily the number of people who came were white males who were from the city of Sacramento, right? But with intentional grassroots organizing, we were able to get some 40,000 people to apply for the commission, right? And then eventually, when they had hearings around the state, 20 to 30,000 people actually attended the hearings or provided testimony in some way. Now imagine, in 2001, the total number of people who were providing testimony was no more than this room. And in 2011, we're talking about over 20,000 people participating in that process. It's just tremendous. And I went to this particular hearing showed up 2 hours early thinking, you know, I'll just sit there and do a little bit of work, only to find that there was a line forming already. It was like going to a rock concert. People were excited about providing testimony to this commission because they felt that they were going to be heard. Next slide. This is the group of 14. One of the other big fears was that it wasn't going to be diverse enough, right? Who was going to apply? They weren't going to represent California's diversity. Let me just say that it clearly is diverse, but we're currently involved in litigation now to defend the commission against Ward Connerly, who is challenging us for taking race and gender too much into consideration because he didn't like the complexion of our commission. Next slide. Next. So what did we have before? We had districts that were largely non-competitive. And for those of you who want to link money and politics, this is Duke Cunningham, who represented San Diego, a district in San Diego, took about $3.2 million from the defense industry, some directly in bribes, some in the form of gifts like yachts and apartments and prostitutes, some in the form of kickbacks where he sold his house to a defense contractor and then got it sold back to him for a cut rate price, right? Duke Cunningham had an indictment hanging over his head, and he was still reelected time and time again. And the reason why was because the district had been drawn specifically for him and by him, and he could not go beneath 55% of the vote because he had cherry-picked all those voters. He had to be convicted before he was finally removed from office. He actually was reelected with the investigation happening. So what do we have now? We have lines where, next slide, the race is so close that it was down to 200 votes. And in this situation, Scott Peters beat out Carl DeMaio, but the point just being that this same area, by redrawing it to put together communities that really made sense, was able to create a situation where there was a competitive race, and voters for the first time said, somebody's talking to me. Somebody's bothering to try to earn my vote. Next slide. I will just say that there are a lot of organizations, both for and against the commission, who were very worried about the outcome. But in the end, we came together and really were able to create joint materials and do joint outreach. And we're now talking about what those possibilities are in other states as well. Next slide. So, top 5 target list. Virginia, the courts just came down and sort of decided that the lines that were drawn by the legislature were not acceptable. So they had to go back and redraw. Ohio, in November of 2015, the voters just voted to make the legislative process that's drawn by a commission far more fair on a partisan basis. In Illinois, they've got a ballot measure that will be hopefully appearing on the ballot in 2016 of November, has an opportunity to create a redistricting commission very similar to California's. In North Carolina, because of litigation, the courts have kicked out the lines, and there is an opportunity to really redraw those lines in a way that is much more fair. And then there's several other states that are now pushing for reforms, whether that's through the initiative process, through the legislative process, or through litigation. Next slide. So if you look at the bright purple lines, that's, and by bright purple, I guess this is whatever color that is. Fuchsia, right. Brilliant purple, a brilliant orchid, I think I heard on Project Runway. But that, that color is where there is some type of reform effort happening or being litigated as we speak, right? And so you can see that there is a pretty active discussion. Largely, this has been happening even before the Supreme Court came down with its Arizona decision where they affirmed the right of citizens to create commissions and to change the law on this. But these things have been percolating, but it certainly has been jump-started by the Supreme Court's decision, and we're hopeful that with a new composition of the Supreme Court, we'll have even more energy moving into this fundamental change.
Thanks, Kathy. And the story of Passage is not boring. And in fact, if you haven't seen it, watch Gerrymandering. Kathy doesn't even get any kickbacks, do you?
No, I get nothing.
Should be a fundraiser next time. Okay, so we have a little bit less than a half hour left, and so I'm just going to take the prerogative and ask the first question, and then we'll open it up for additional questions from the audience. I think after the first question, we might have to excuse Ernest, who has to catch a plane, so it'll,
I've got 20 minutes, I think.
it'll be a really good question. Yeah. Okay, so Kathy started it off and alluded to we will have a new Supreme Court justice in the not too distant future. Who knows when we will have a new Supreme Court justice. And so I would just love to hear from each of the panelists about what you think the potential impact on voting rights is and what strategies you're thinking about to shape future jurisprudence in this area.
Ernest, you're the one who's time pressed.
Well, I'll talk about Texas really quickly because I have because Texas, this vacancy is brought up. There are three big Texas cases that are going forward that this vacancy could affect. One that many of you have probably heard of, Evenwell. Evenwell is out of Texas. MALDEF tried to intervene with its clients, but didn't get in. We wrote an amicus. But Evenwell could be a tectonic shift. And depending on what happens, we don't know if they voted yet, that is a big one. Another one is Texas redistricting, which Allison and I worked on. That one is still sitting in San Antonio federal court in front of the three-judge panel. There is no ruling, but as many of you constitutional law students know, if whatever decision is made, it will go up to Supreme Court, and assuming a 4-4 split, that three-judge panel decision will stand. And that is important because there are claims of intentional discrimination and requests for a remedy under Section 3C of the Voting Rights Act, which could loop Texas back in under Section 5 coverage. And if the three-judge panel were to rule for 3C, basically them being roped back in under Section 5, that would stand under a 4-4 court. Of course, we'll see. Voter ID, there was, after the semi-favorable decision on voter ID in front of the Fifth Circuit, Section 2 took it down, but there was no finding of intentional discrimination. It's been sent back, it's been remanded for that. But there was an appeal by Texas trying to attack it attack Section 2 essentially. That could be affected by, the vacancy could affect that case as well. So three very concrete moving forward examples, and I'm sure other ones to come if there's a vacancy for 2 years.
Let me just push you a little bit more. In terms of like the longer term future, and anyone can answer this as well, do you think it's just good enough to have the Supreme Court say, actually, that formula based in many decades ago is actually okay, and therefore we have Section 5 now, and that old coverage is now up and running again? Is that the future, or is there something else?
Mm-hmm. So, unless you want to answer this, okay. There's a seminal case, Jingles versus Thornburg, where the Supreme Court defined what the elements were for finding a Section 2 claim under the Voting Rights Act. And in short, what the Supreme Court said was if you can show that you can draw a majority-minority district and that there is polarized voting, that is that the minority population is voting one way for the candidate of their choice and the majority population is voting the other way, that you can show that there is racial gerrymandering and that those districts need to be redrawn. What I think Allison alluded to and a lot of us have been thinking about is that with the changing demographics in a lot of parts of this country, between minority groups that are now majority, but majority oftentimes in a coalition situation where it's not one group that's majority, but when you put many different groups together thoughtfully, right, where they share interests, that they might form a majority. But also in situations where minority communities are now spreading out, right? They're dispersed. And so it's not so easy to draw a nice compact district because minority communities are not just confined to the south side of the tracks, right? So certainly in Southern California, we see a large African-American population moving out east to San Bernardino in the desert because that's where the affordable housing was, right? How do we accommodate or acknowledge that there is still racially polarized voting, right? But that trying to draw a somewhat compact majority-minority district is no longer the only solution. And for many of us, we've been thinking about whether alternative voting is a possibility, but also whether we need to think about other approaches, putting on the table the viability of coalition districts, the viability of thinking in non-geographic terms about how we can ensure proportional representation. Okay, big concepts, but I think that in the voting rights community, this is a really important conversation for us to have because it will define how we achieve inclusive democracy in 2017, 16, and beyond. Let me just put on the table another thing that we've been thinking about, which is in terms of this Supreme Court vacancy. So in Jubileer versus Veith, Justice Anthony Kennedy said that, and he was agreeing with several of his other justices, that there is a serious problem when it comes to partisan gerrymandering. There is a legal standard for racial gerrymandering, but we're not so sure about partisan gerrymandering. We know it's a problem, but we don't know what the legal standard is to find when it's crossed the line. Okay. Time and time again, the courts have said that incumbent protection and partisan motivation is an acceptable excuse for cutting communities up. Okay. But we think that Anthony Kennedy's dicta in Jubileer versus Veith opens up the possibility that maybe there is a line to be drawn, a standard to be created by the courts that says this goes too far. This kind of partisan gerrymandering crosses the line and we're going to unwind that districting. We believe that there are a number of scholars who are putting out proposals for what that should look like, but we think that the vacancy opens up that conversation to a much more honest discussion to recognize that we have allowed partisan gerrymandering to get too far in the U.S. and we need to rein it in.
Allison, do you want to add anything else?
I think from our perspective, we've got a number of cases heading up to the Supreme Court in the next year or so, and the key is that Justice Kennedy has often been the swing vote on race cases, particularly redistricting cases, and so losing Justice Scalia may not necessarily affect how the court, so we think there could be some 5-3 things coming along. But even where there are 4-4 decisions, so where we lose Justice Kennedy, or we never really had him to begin with, there's some potential for some really inconsistent decisions and law out there. So Virginia is a great example. You have 2 3-judge panels that go directly to the Supreme Court. One struck down the congressional redistricting, the other upheld the state legislative redistricting, same claim, same theory that I talked about earlier that Virginia applied in its redistricting. So if Justice Kennedy isn't interested in understanding how racial gerrymandering has been used to the detriment of voters of color, and those end up being 4-4 decisions, you've got 2, in the state of Virginia, very different legal principles, now law. So that's a little bit unsettling for practitioners, I think, and for voters. It's uncertain. But then we've got cases like where we have good panels in lower courts, and seeing those decisions being upheld would be a great thing. So just it's hard to predict now what exactly would happen, but in the next year, there's going to be a lot of important redistricting cases headed up there.
Great. So we have a mic, and so we'd like to take 3 or 4 questions from the audience. All right, let's go back here. And Larry, could you introduce yourself?
Yeah, Larry Ottinger. I'm here today with the Ottinger Foundation, and I'm very excited to hear, well, first of all, I had the pleasure of working with Allison very briefly on the Texas redistricting case, so I hope you are able to recoup attorney's fees. So I'm interested about the mention of alternative voting and as a possible remedy. And I know a little bit about Rob Ritchie and the fair vote and his discussion of ranked choice voting. I wonder if you can discuss how, a little bit in more detail what your thoughts are in terms of the different types of alternative voting systems and what you see happening in that space in the voting area.
So it varies dramatically from jurisdiction to jurisdiction. We worked with our clients in Lee County to explain that in their situation, it actually limited voting for having a fewer number of votes you got to cast compared to the number of seats open was going to be the most effective for them in being able to elect a candidate of choice. So cumulative voting, where you get to concentrate your votes behind one candidate, may work better in some jurisdictions. It really depends on the demographics. It depends on what kind of organizing you have in your community, because like single-shot voting in at-large systems, your ability to use alternative voting systems to the benefit of communities of color really depends on two things. If voters understand the alternative system to begin with, and two, if they understand how to use it. So explaining to voters, to having advocacy groups explain to their constituents, this is how we would use cumulative voting to ensure a voter of color, a candidate of color got elected. I mean, that is really critical. So there are some, this is not a one-size-fits-all situation. There are some jurisdictions where alternate voting is just going to be a no-go for a while, partly because of demographics, partly because of organizing infrastructure. It's not something, it's definitely something that has to be a conversation, a long-term conversation. We had an experiment in North Carolina with instant runoff voting, which isn't exactly alternative voting, but it's ranked voting. And we used it statewide in judicial elections in 2010. The legislature repealed our ability to do that experiment when they took when conservatives took over in 2011. But one cycle wasn't going to be enough either. So there's this initial resistance to, this isn't what I'm used to, I don't know how this works. But then it's going to take more time. So the way we approach it is, let's talk about it as an education project to begin with. Let's talk to voters about what would this look like, where are examples where it's been used effectively, and I think we in this room can do a better job to advance the option for alternate voting systems by sharing those success stories. Fair Vote does a great job of it. But there are diverse communities using alternate voting systems right now, and capturing those stories, creating narratives about why they worked in those areas and why your jurisdiction that's considering it is comparable. Our ability to do that effectively is really going to be key to talking about alternate voting systems in the future.
And just a fun fact, Illinois had multi-member districts with cumulative voting for over 100 years.
Oh, sorry. I'll just add that. So in California, we have adopted a new statewide standard. I guess it's not so new anymore because it's been around for a while. It's called the California Voting Rights Act. And that formula that I said before, where prong one was to look for whether or not you could draw a majority-minority district, and then prong two is to find out if there's racially polarized voting. We now have a system where you just need to show prong two, that there's racially polarized voting. So what that has opened up a lot of our local jurisdictions to is litigation to challenge at-large systems, and where the possible solution could be districting, but the other possible solution could be alternative voting systems. We have a couple more hurdles that we're working on in California to remove in order to allow jurisdictions to choose a variety of vote allocation systems, right? We do have, I think, 4 jurisdictions in California that allow for instant runoff voting. I'll just end on this. When it comes to grassroots mobilization, probably one of the best examples was in Oakland, where the community really rallied to utilize this new system of instant runoff voting. to unseat a very well-funded, very entrenched incumbent. That community group, Oakland Rising, continues to organize using instant runoff voting as a tactic that they educate the community on, so that everybody knows when they're marking their ballot to indicate their first three choices, 1, 2, and 3, they're doing so in a conscious and intentional way, not by accident. So I think that when we think about these systems, we've got to move from it being something on paper to something that feels like it's part of a strategic decision by grassroots organizations. The last piece that I'll just say is we view a lot of these alternative voting systems as one of several tools in our toolkit, right? And so while we think about, some states that have the initiative process being able to entertain the idea of having citizens commissions, we also think that there are other ways to get at greater representation, more inclusive representation. Sometimes that is about changing the electoral process.
Let's go to Marcia.
Thanks. This is a great conversation. You started alluding...
And introduce yourself, please.
Oh, sorry. Marcia Johnson-Blanco with the Lawyers Committee for Civil Rights Under Law. You started alluding to this, but I'd like you both to expound more about, I like Kathy's framing about how we can be intentional and, what was the other term you used? I lost. But in our organizing, as this is a season now where we're all focused on the election, and then, hopefully we survive and start thinking about what next. But how can we use the heightened attention now that we're experiencing and in the work we're doing to help paving the way for the reform discussions and other discussions moving forward? I'd love to hear your thoughts on that.
Well, I was talking to Kathy earlier today about using a court decision, a favorable court decision, to really spur conversation, and this has happened in North Carolina. So we've been talking about redistricting reform in North Carolina for a very long time. Having a federal court strike down the congressional districts, it really ramped up the conversation. So we've been working with Common Cause North Carolina and a bunch of other groups to capitalize on that media attention so that folks who might not normally be part of this conversation get brought into it. And sometimes it creates unlikely allies. Our Republican governor, who's facing a really tough re-election campaign this November, suddenly decided to announce that he thought it was time to look at an independent redistricting commission. We may not trust him any further than we can throw him, but it's a conversation starter. And so I think what we have to be intentional and thoughtful about is weaving together all of these pieces. So you can't have a group together sitting down talking about election protection work without talking about the reason we find ourselves with all of these onerous voting restrictions is because the way power is concentrated and determined in the redistricting process. So I think that from my perspective, at least in North Carolina, the intentionality comes in not siloing off the different topics and not just saying, well, Common Cause is the redistricting reform group and Democracy North Carolina is the voter suppression group. Really, when everyone is down sitting at the table together talking about how to weave these discussions together.
I would say that, well, first of all, President Obama incorporated into his last State of the Union recognition that gerrymandering is a fundamental problem that we all need to come together around. And he specifically called on us to make this into a bipartisan call to action. This isn't a Republican problem or a Democratic problem. Depending on what state you go to, everybody engages in it. It's a power problem, right? And I think you'll see that in blue states, it's always the Republican governor who champions redistricting reform, and in red states, it's always the Democratic governor or legislature that's championing it. What we need to do is to sort of say, is this an issue of fundamental fairness? Is this how we do this? Or do we put people back into the driver's seat? And if that is what this is about, putting people back into that driver's seat, then it doesn't matter whether we're pursuing these strategies in blue states or red states. It should be a kind of across the country thing. The intentional part, what I would say is that if I look at California, it was a hard push to achieve statewide change. And in particular, our fiercest opponents were actually coming from the Democratic establishment. At that time, it was Nancy Pelosi and Howard Berman and other people who, clearly saw the challenge to the redistricting process as something that was a challenge to their own power, right? Since then, they've become aficionados, which is kind of amazing. But what we're also seeing is at the very local level, from school board to city council to counties, there is a revolution happening in California where every level of government, people are asking, why do we do it this way? Why don't we put citizens in charge? And why don't we think about other ways of voting, right? And so what we've been able to do, and I shouldn't say just Common Cause, this is a huge coalition of organizations that are working to organize people at the grassroots to think about all the possible tools that are in the toolkit and reshape that. Now that's possible, I guess one would say, on the left coast, and it's possible where you have initiatives. In other places, I think we have to look to a litigation strategy in order to open that up. But what we should be doing is, when that litigation results in a court finding that the districts should not stand as they are, we need to be open to asking, so what should the alternative be? And not always fall into the same set of limited traditional tools that we've always looked at. The last piece is just that in California, with the redistricting process opened up by our California Voting Rights Act, a lot of organizations have now said, we shouldn't assume that just because we're moving from an at-large system to a district system, that the people who should draw the districts should be incumbents themselves. And that has really, I think, at a very super local level, when you think about for school board, when you think about, for us it's water boards and mosquito abatement districts, the idea that the community would get involved in drawing those lines is also a pathway to power for a lot of candidates of color, right? Because that's where you start, is at the school board level and the mosquito abatement and the water districts. And so if we thought about this as an organizing strategy, and Marcia, you and I know, we look at sort of what the other side does and we say, oh my God, they're always 10 years ahead of us and they thought it through, and they've got think tanks and people placed in places of power. But part of this is, what we have is the people on our side. And with just a little bit of intentionality, I think we can catch up.
I think we have time for one last question. Ellen in the back, please introduce yourself.
Yeah. Oh, thank you. Alan Davis, the Why Not Initiative. So there's a 13.7% chance that the Democrats are going to hit a grand slam home run this year. President, House, Senate, and Supreme Court. What does 2017 look like in terms of these issues? What's your fantasy, or what do you think is really going to happen under those circumstances? I'd be interested in all three of you commenting on that.
What I think I would love to happen is that if the Democrats took power, that they would actually take political reform seriously, as opposed to now we need to exact revenge on the other side. Who's to say who will be in power in the distant future? So why not actually have a strong democracy so that we have good public policy, as opposed to let's just work the system for our benefit in the short run.
I'd love to see a lot of amendments and corrections to the Voting Rights Act. So the Voting Rights Act, we lost Section 5. Parts of Section 2 have gotten chipped away. Our ability to get injunctions before bad voting laws go into place is challenging. If we just win on the Supreme Court, it's hard to see, absent some sort of congressional action, them just revisiting Shelby County. But there are a lot of the groups in this room have been working on supporting Voting Rights Act amendment and authorization in Congress. And if we got a grand slam, that's where I'd like to see a lot of action.
I think that it was Norm Ornstein who said this morning that what we really should be pushing for is 100% voter participation. And the reason why I think that is so critical, thanks, I didn't say it, but the reason why I think that's so critical is because I think that if we have even close to that, and I realize then that America that we're just shooting for 75%, that would be good enough, but even if we got close to it, it would mean that those who are elected could not take the people for granted. I'll tell you what, in California, again, you think that in the left coast it would be so easy to pass things like online voter registration and same-day registration, right? But the political establishment, whether that's Democrats or Republicans, are scared to death of the idea that everybody would show up to vote. Because if that last, whatever that is, 13%, 15%, 40%, showed up to vote on a regular basis, not just in presidential elections, but in the other years as well, we would have a true revolution, because then we would be holding our electeds accountable and they couldn't just go back to the usual way of doing business. Our challenge is to make the laws possible to create not only reduced barriers to voting, but incentives and situations for there to be true interest in our elections, which means getting at the motivation for why people come out to vote. We know in 2016 that there's going to be a lot of attention because we've got close races, right? And so what we need to just keep asking ourselves is, why is it that so many Americans check out? It partly is because of the barriers, but it's partly also because people feel like the system is rigged. And so we need to go to the heart of that matter and to say, how do we unrig that system? How do we create a situation where there's actual competition, where there's actual choices for voters to make, and where I feel like my vote will matter both in the election, but ultimately when somebody is elected to represent me.
Please join me in thanking our panelists.